Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in.
Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Each Friday morning at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. Our guest this week is Michael Stack of Bricker and Eckler. Michael is the Practice Support Director at the firm, a leading Midwest firm with offices throughout Ohio and with clients across the country. A licensed member of the Ohio Bar and the Florida Bar, Michael provides litigation and technology support to all practice groups in all areas of eDiscovery across my favorite, the EDRM lifecycle, while applying best practices and using state-of-the-art legal technology tools. He's got over almost a decade of experience in eDiscovery and previously served as an eDiscovery project manager and contract attorney with clients including Fortune 100 insurance company and a business litigation boutique firm, just to name a couple. He earned his JD from the Florida Coastal School of Law, where he was the technical editor of the Florida Coastal Law Review and an award-winning oral advocate on the Moot Court Honor Board. Michael, welcome.
Thank you, George. It's a pleasure to be here. My thanks to you, to ACEDS, and to Reveal for having me today.
Glad to have you join us. Today, for our discussion, I'd like to talk about the evolution of eDiscovery technology and the effects it's had in recent years on the way its law firms provide their services to clients. Before we start that, however, let's talk about your current role and what you all are doing at your firm, just to give people an idea.
Absolutely. So I am the Director of Practice Support, which is kind of an amalgamous term. And I'll share with you that Bricker and Eckler has recently rebranded this department from litigation support. And so when people think of eDiscovery, they typically think of litigation. Rightfully so, discovery is right there in the name. And so the litigation support department at Bricker was primarily tasked with identifying, collecting, analyzing, and producing ESI in response to litigation. Like you said, something near and dear to all of our hearts as eDiscovery practitioners, the EDRM lifecycle. And so when I started in this role, we rebranded the department as Practice Support. And the goal was to find opportunities to leverage technology to add value for all of our practice groups and all of our clients in new ways that aren't just in response to litigation. So maybe that's information governance and data management on the front end. Maybe that's analyzing part petitions for constitutional ballot issues. But it starts with technology and the expertise needed to leverage it.
Part of that, of course, is the technology itself. And part of that increasingly is AI, its use and adoption. What are you doing with AI there? What are you hoping to do with AI?
It's funny. Earlier this week, NPR aired a piece on Marketplace Tech, I believe, about the perceived interchangeability of the terms algorithm, machine learning, and artificial intelligence out in the general public. And why it's important to understand the difference as the technology becomes more sophisticated and more influential. And I started to think, coincidentally enough, given kind of the broad topics that we had planned to go over today, um, whether there are any parallels to that idea in eDiscovery and the legal industry and how we approach eDiscovery technology here at Bricker as well. And, I think the answer to that question is yes. If you think about some of the traditional elements of, supervised machine learning in TAR, technology assisted review, that's kind of the branch of quote unquote AI that most folks are familiar with in eDiscovery. This idea that you take a seed set with, usually hundreds and hundreds of documents, you train the seed set using a binary yes, no, responsive, non-responsive coding panel, and eventually the machine, the AI, spits out predictive coding scores for the remaining documents that saves time and money on future review. Uh, Generally speaking, that works great for substantially large data sets. But what about some of the smaller matters, smaller data sizes, smaller budgets? And I think something that really excites me as an eDiscovery practitioner, something that we're seeing for sort of traditional law firms as they move into AI and start this adoption process. Some of the new elements or newer elements of unsupervised learning, of computer vision, are kind of changing that AI adoption model and how prevalent it becomes in smaller to medium sized firms that aren't working on enormous 10 million document cases in eDiscovery. And a couple of things that come to mind. Portable customizable AI models is one. This idea of kind of the next generation of natural language processing, sentiment analysis is a huge one that's coming down the pike and already here in most regards. Instead of reinventing the wheel for each individual matter, we now have these prefab models that recognize documents related to privilege, discrimination, terms and conditions of a contract, and so on. Another one that stands out, I think, is video and image detection and contextualizing that information. The idea that you can take 1,000 pictures of a construction site and flag only the ones showing underground pipes, or take 100 hours of deposition video recordings and flag only the ones discussing labor and employment issues, and including related timestamps for that information to make things quick and easy. Uh, I think those types of sophisticated data analytics, the quote unquote new models of AI that are coming and that are here, ones that can be easily replicated and customized for specific matters with little human input on the front end. I think that's an immensely powerful tool that opens the door, for huge time and expense savings over manual human review. Do we have
So,
time for a quick war story?
sure we do. Go ahead.
All right. So when I was in law school, I was a legal intern at the U.S. Attorney's Office, and there was a particular week where my one and only task was to pour through hours and hours and hours of prison inmate phone call recordings. And the thing that kind of surprised me the most was how open and honest folks are when, number one, they know they're being recorded, and number two, they're likely sitting in a phone bank with 20 or 30 of their closest friends, right? Man, some of the topics being discussed there were very frank and very personal, and I would have been absolutely happy to let a machine do that review for me that week. um, but anyway, as kind of this underlying technology gets better, I think the next logical step and another thing that's really adding to this adoption is, increasing the user interface and the UX such that you don't need a software engineer to administer it. And that ability to plug and play or plug and analyze, I guess, is helping drive that adoption of AI and eDiscovery even more. And that's particularly advantageous for smaller matters with tighter deadlines.
So we know from anecdotal information, as well as at least a limited number of studies people have performed, that when you talk about TAR and TAR, whether it's TAR 1 or TAR 2, adoption rates generally are quite low. There are a few folks in a few firms that are making good use of those technologies, not many. It sounds as if you think that these other forms of AI, when used in discovery, are going to help really increase those adoption rates. What's the difference there between the two? Why more adoption potentially in one area than the other?
I think one thing that comes to mind is ease of implementation. This idea that where with traditional TAR, you number one need someone who's essentially a software engineer, technologist to be able to set all of this up and administer it behind the scenes, behind the curtain, as it were. Someone who specializes in more of the technology piece to even be able to get something up and running. And then you need a lot of man hours on the front end from the subject matter experts and a case team and a review team trying to train the machine in order to code the documents and uncover insights into further review. I think the ability to kind of plug and play these new models, there exists a model somewhere out there that's looking for almost exactly what we need. And we can make a few small tweaks on our end, a few clicks of a button, and apply this already existing AI model to help us cull down our data set immensely. And I think that extra help in implementation, the ability to just carry over an existing model and plug it in where you need it, I think that is going to help drive more adoption of AI in the future.
So it sounds as if some of the key parts of this aren't the technology itself, what the AI can accomplish, but how complicated or easy it is to use the technology, how quickly people can get results back, how evident the value of what they're doing becomes to them. Is that what you're saying?
I think so. Yeah, and there's always kind of this there's this balancing scale that has to be undertaken, right? Anytime you walk into any matter that involves eDiscovery, there's always going to be that balance of expense to efficiency. How quickly can we get the information that we need? How expensive is this going to be for the client? And as much as winning, a good result for your client is, you certainly have to be, if nothing else, at least cognizant of all of the surrounding hurdles that come with that, whether that be implementation or expense. There's always kind of this battle between, the ability for the technology to help out and how much time and resources you can throw at the matter.
When we talk about things such as predictive analytics, sentiment analysis, computer vision, and we talk about that in the context of a law firm, we've got some competing cultures, law firm culture versus tech culture. What are your thoughts on that?
Yeah, so I think there's certainly a bit of, I won't say a competing interest, right? There's sort of a duality between law firm culture and tech culture. And I think a lot of that gap exists, let's say, between the duty of competence and what I'll call innovative spirit. I think it's a necessary gap, mind you, but a gap nonetheless. Um, Are you a cinephile, a fellow cinephile by any chance? A big fan of movies? Have you seen the original Jurassic Park from 1993?
Now, I have a colleague, Jay Lieb, who I think has seen every movie ever made. And he is constantly dropping quotes from movies, constantly disappointed that I don't catch the reference. This one, however, I have seen Jurassic Park. So go ahead.
I felt compelled to ask, and so if you recall the film, Jeff Goldblum plays a wonderfully colorful character named Dr. Ian Malcolm, a mathematician, and in one of the scenes, he's speaking with the owner of Jurassic Park about harnessing the power of genetics to recreate dinosaurs and extinct species. And I'll paraphrase here. He says something to the effect of, "You were so preoccupied with whether or not you could do it, you didn't stop to think if you should." And so I think there's this ever-present battle between can we do it versus should we do it? Speaking in kind of broad generalizations, um, the advance of technology allows a bit of freedom to innovate for the sake of innovation. Business constraints aside, there's always a goal for tech firms, but generally speaking, there's kind of this mentality that we can invent the thing now in the name of science and discovery and figure out the applications later. And for law firms and attorneys, there's less leeway there. Attorneys don't have as much opportunity to engage in lawyering for the sake of lawyering. And I think about Thomas Edison had an often paraphrased motivational quote about failure and finding 1,000 ways how not to make a light bulb. Uh, Attorneys and their clients rarely get that second bite of the apple, much less 999. And so the focus must always be on the client's desired outcome and, frankly, perfection from the outset. And I think that focus can lead to hesitation in adopting new technology. And so as a practitioner in eDiscovery, you kind of have to shore up the technology first, make it fit into the practice, into the representation, and not the other way around. And it takes a tremendous amount of expertise and experience to bridge the gap and make that happen. Um, a
What are
recent example that I can think. Go ahead.
Go ahead. Go ahead.
uh, one recent example that I can think of is kind of this, state of the law and state of technology dichotomy is, e-discovery and courtroom technology in response to COVID. You had this very impressive use and adoption of courtroom technology, remote technology, e-discovery technology during the COVID shutdown. And it was incredibly impressive, how quickly the courts were willing to adapt and change in order to keep, the wheels turning during this COVID shutdown. And on the flip side of that, we had things like the infamous lawyer cat incident on Zoom. Are you familiar with that one from early to mid 2020?
I think every lawyer on the planet must be familiar with that one.
Yeah, and so the particular event was about remote video conferencing, but we had this incident of the practice of law, the electronic practice of law going viral, and the resulting spotlight that it created. And the broader implications there, I think, are certainly applicable to e-discovery. As a result of this increased electronic practice, there's a plethora of new ethics committee opinions, new CLE requirements, procedural rules, and we talk about this ethical duty of competence as it relates to technology, and that includes e-discovery technology. And so I think that zealous advocacy on behalf of your clients has to include to some extent this competence in the technology that's related to e-discovery and how you have to conduct the practice of law in the current digital age.
On the ethical duty of competence, one of the interesting things I think about it is while there are, I forget, 39 or 40 states, something like that, that now say that lawyers have an ethical duty to be technologically competent, I think none of them have yet defined what that actually means. What are your thoughts about what that? So we don't have a definition to work with. What are your thoughts about what that definition should look like?
Well, luckily, the practice of law is generally self-governed, uh, lawyers governing other lawyers, and so there has to be a recognition that technology is always changing, and it's really difficult in the practice of law, I would think, to keep up with. Not only do you have to keep up with the change in law, but the change in technology on a day-to-day, hour-to-hour basis. As far as what I think it should look like going forward, it's certainly not a requirement that practicing attorneys, that law firms need to be, you know, tech vendors, as it were. We don't necessarily need to have attorneys who were trained in software engineering when they were coming through law school, but there certainly has to be a realization that in the new digital age in which we live, there needs to be some competence in technology that's related to remote practice and e-discovery. Um, and what that looks like practically speaking, it's kind of hard to put black and white rules around something that's always changing. At a minimum, it's about recognizing that the technology is out there, and if nothing else, being competent enough and recognizing the need enough to, if you yourself aren't a technologist, to at least surround yourself with the knowledge and the expertise that you need to continue to practice successfully, and make sure that that education and training is there so you can get up to speed and provide that most effective representation.
With the increasing use of technology, with the requirements that lawyers be technically competent, whatever that means, with the growing array of capabilities, that's got to have an impact on the service models that law firms use. What changes are you seeing in that arena?
So the increasing technology definitely has an effect on the kind of service offerings, the service models that law firms are providing for clients. We've kind of traditionally think of law firms obviously as being a legal service provider. For a long time, law firms have been kind of business partners as well, right? Recognizing that their clients might have business needs that need to be taken into consideration and creating that partnership. But with the ever increasing, I would say, onslaught of new technology, new data types, new data collection and processing hurdles, there's now this kind of underlying requirement that law firms start at least recognizing and offering some services as IT service providers or forensic collection experts. The convenience of modern communication is a bit of a double-edged sword for e-discovery practitioners. You have this simultaneous cost explosion for firms and vendors providing legal services or legal-like services. And then on the flip side, a wave of cost consciousness on the part of clients. And it's creating, we talk about kind of this success mantra, do more with less. And I think that's more applicable now perhaps than ever. One area where it's really creeping up for law firms in particular is in e-discovery budgeting. In addition to having to be successful in subject matter areas, legal procedure, technology, application of that technology to your legal problem, you also need success in e-discovery uh, to look like and be predicated on a plethora of factors that are outside of the firm's control as well. Data size, format, availability, demands of courts and the opposing parties. Um, these variables create huge swings in e-discovery expenses. And so the complexity and cost is so great that some firms are outsourcing eDiscovery work entirely, and rather than suffering the headache and the exorbitant expense. But there are some firms out there that are taking the challenge head on, meeting the technology and the data where they are, and coming up with creative ways to build bridges between technology, the practice of law, expertise and expense, and adding value for clients to ultimately achieve their desired goals.
One of the things you mentioned there was in potential increase by law firms in efforts to collect data. That has been in many ways a third rail, I think, for law firms. They've been often quite leery of doing any preservation and especially collection work, feeling they need to leave that to others. How is that changing? What's bringing about that change?
And going back to kind of our earlier success mantra, right? We're talking about this cost consciousness on the part of clients and the request for their service partners and for their law firms or outside counsel to do more with less. And so, there's always this balance between, as you mentioned, the technical expertise and complexity of collecting data in partnering with your outside counsel, for example, rather than outsourcing it to a third party. Is this a situation in which we can collect this data in-house, but have it be defensible enough and cost conscious enough to merit the risk? Or is this something that we need to farm out to a third party expert in forensic collection? And a lot of that comes down to, nature of the data, nature of the matter, and cost consciousness plays a huge part in that. And I think at the end of the day, what's really important to keep in mind is at the heart of eDiscovery, at the heart of data is a very simple proposition. What you're doing is leveraging data to provide added value to clients. And the power of technology, the increased efficiency that comes with it, can provide this additional insight and this immense cost savings for clients in the long run. And I think law firms are trying to leverage that knowledge and that ability to gain insight and gain cost savings. And if the technology and expertise is there, that's some of the value that can be added by having a law firm conduct this this part of the eDiscovery process for a client.
Not every initiative that law firms launch where they think it's going to be embraced and adopted by clients succeeds. And that includes sometimes some of the cost savings measures. How are you seeing clients reacting to all of this?
The answer depends on the clients. I think there are some clients that are clearly receptive to partnering with their firm, with their outside counsel to engage in eDiscovery. There are some clients that are less amenable, right? And so the trick for eDiscovery practitioners is to clearly communicate and demonstrate this value proposition across the board, frankly, but especially to clients. That recognition of the value that it can provide is something that needs to be clearly communicated, and that's one of the prime directives for eDiscovery practitioners that are partnering with their clients to add that value and that insight.
Well, thank you, Michael. Michael Stack is the practice support director, not the litigation support director at the law firm of Bricker and Eckler. And I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Michael, thank you so much for joining us this morning.
Thank you, George. It's been a pleasure.